And so if there are two documents that have been cited and looked into in the past few days, these two documents, the Nigerian Constitution and the APC Constitution. And the reason we're going to delve into tonight. It's few hours before the All Progressives Congress, World Congresses, which is expected to hold across the country. The caretaker and extraordinary convention planning committee of the party says the World Congress to elect party executives will still hold as scheduled, but there are still those in the party who believe in the party is threading on a various dangerous path, and so we hope to hear more from the party and its standpoint on this matter.
Screening of aspirants and the World Congresses that is scheduled for tomorrow, 31st of July, 2021. And afterwards, as from 2nd to 7th August, there is going to be another committee that is called Appeal Committee that will also be in Lagos to listen to any appeal if it arises. It is also agreed that the venue of the Congress or the election of the members is going to be the APC ward offices. The mode of election, going by the guidelines, is stated that A, there should be consensus. All party positions prescribed or implied by the party's constitution as above stated for the Congresses shall be filled by democratically conducted elections at the respective Congresses. However, for peace and harmony, the party encourages emergence of candidates through consensus in the first instance.
That is the situation for you in Lagos State. In Osun State, there is confusion. In Bayelsa State, in fact, there is more confusion. Let me tell you what is happening today. Coming from the High Court in Yaragua in Bayelsa State, there is an interim order that has been obtained, a motion ex parte that is stopped tomorrow's exercise in Bayelsa State, and the court has held the party World Congress tomorrow, and he has adjourned the case to, I think, the 8th of August. The 8th of August to hear the matter. The case is adjourned to the 9th of August, that is 2021, for hearing of the motion on notice. That is the situation. In Lagos, there are those who are saying that they paid for forms, they have not received it. But the GAC in Lagos has said it's going to be consensus candidate. The group called the Lagos for Lagos are saying that they have been sidelined. In Osun State, in fact, the dichotomy or the differences between the governor and the former governor is obvious, as the side to the minister are saying they are not aware of what is happening. So where does the APC go from here? So we'll be getting to hear from the man who has been at the center of all of this legal matter. There's been debate about what the Supreme Court said and the way forward for the APC. I'm being joined by a chieftain of the party and the senior advocate of Nigeria, Chief Adeniyi Akintola. He joins us here in the studio. Thank you so much, Chief Akintola, for coming tonight.
Thank you for having me.
There is a confusion in your party, and you have been at the center for your position. Not only that you're a chieftain, you're also a senior lawyer. And I saw the press conference which you had, and it does look like a lot of people are wondering, where is it to go? The Supreme Court seems to have identified that should Section 183 of the Constitution be valid in your case, that means there's going to be a problem for your party. What is the true position of things?
Well, I don't know why all the noise, all the hullabaloo, no. I mean, it's almost unnecessary. There's no confusion in our party. The party is stable, strong, and waxing stronger. Look at the situation. Quite a number of people who have been commenting, with due respect to many of them, they have become out of ignorance. Some of them out of mischief. And of course, some, for one reason or the other, because of the tendencies in their various states, you have to appreciate the fact that in a political party, intra-party dispute is much more stronger than inter-party dispute. And like you say in Yoruba, I mean, I wouldn't know how to put it, if you don't have problem in your home, as it were, you probably will not have outside your environment. There's no problem. The Supreme Court has not created any problem for anybody, except those who want to fish in troubled waters. The case they are talking about, at least I was in that case, and from inception, from the tribunal to the Court of Appeal and to the Supreme Court. Most of the people who have been hitting their heads against the wall, ask them, who are the parties in the case? Who are the lawyers in the case? What were the issues canvassed? What was the judgment given? What was the ratio of the judgment given at the tribunal and what was obtained at the Court of Appeal? As they don't know. But because quite a number of them have other ideas, they have other issues, and they want to canvass that, of course, you have to give them the right to hear their views and say out, voice out their mind.
Chief Akintola, you're
there's,
saying that
there's really no problem.
The problem is extra legal matters. It is not a legal matter.
It is not a legal matter.
Okay, so
but I'm speaking as a lawyer.
Okay, so let's speak to the law now.
Yes,
let's speak to the law,
yes.
legal issue. First and foremost, let me bring up the Section 183.
83, yes.
So if that can be brought to the screen so our viewers can see. Section 183 says, and I quote, "The governor shall not, during the period when he holds office, hold any other executive office or paid employment in any capacity whatsoever."
Yes.
That is a position of the law.
Yes.
So the question is that Governor Memo Malabuni, in the eye of the law, is what is happening the right thing?
Of course, yes. You have to appreciate the fact that the tribunal found as a fact that holding of party position is in no way a contravention of Section 183 of the Constitution. That was his judgment of the tribunal, which was upheld by the Court of Appeal.
But I thought that the Supreme Court said,
no,
it's because
no,
was not joined in that case.
Certainly not. It was the minority judgment. And when as minority judgment becomes the judgment of the court, this is not the first time we're having this type of situation. We had it in 1979, Awolowo against Shagari. There was minority judgment. Popular as it was that the judgment of the court? A minority judgment is a worthless opinion. It's only good for the researchers, the sociologists, and the academics. It's not something you cannot even go to court and cite it as an authority.
No, because
you see, quite a
before,
number of people,
before the party sneezed, before you could feel the sneeze, the effect is being seen. In Bayelsa State, the court has stopped the process.
I wouldn't know. Excuse me, as a lawyer to the party, I'm not aware that the party has been served. Of course, I'm just hearing that from you. The other was obtained of ex parte, and the member that somebody obtained another ex parte. Like we used to say in those days, in the 80s, 90s, they say somebody won Grand 1. You will never hear of Grand 2. So we all this type of thing, people who grandstand and go, we appreciate, we know. Look, we know ourselves.
Okay, so if you look at it, perhaps I should put the position of Festus Keyama forward. And this is
before you go into that,
okay,
address the issue which I had addressed, that particular section of the Constitution had been trashed out by the tribunal. Nobody can deny that. The judgment is there. And after, excuse me, it was said by the court that holding of party position will in no way contravene the provision of Section 183. And if you stretch the argument further, all the governors of APC are members of NEC, of the party, including the president.
But those are not elective. NEC is not an elective position.
This one
is a statutory position by the virtue of their election.
The caretaker committee members were not elected; they were selected. And Article 13 of our constitution, of the party constitution, state emphatically that the party will have the right to constitute a committee. They can give anybody an assignment, including Mr. President. He can be given an assignment by the party. So the mere fact that you are given an assignment, just like judges or justices all over the country being appointed as chancellors in their churches, being appointed as, we will ask them to vacate their position.
That's not an assignment.
It is an assignment.
That is an executive position of the party. The NWC, the second most powerful
Excuse me,
of the
all I have to tell you that particular, it is not your opinion, not my opinion. It has been interpreted by the court. It was upheld by the appellate court. So why should anybody want to hit his head against the wall because of that? It has been interpreted. Unless you don't believe in the rule of law, that particular provision of the Constitution has been interpreted by the tribunal, upheld by the Court of Appeal, and upheld by the majority justice of the Supreme Court. What else do you want? The mere fact that somebody expresses an opinion in the narrative,
it can never be further argued.
You can't stretch it further. After Shagari's matter, there was a matter between the current president against Yar'Adua. I represented Atiku in that matter. Between Atiku against Yar'Adua in 2008. The case started in 2007, and there were minority judgments too, delivered by Justice Aluma Mukhtar, who later became the CJN. Justice Onege, who also later became the CJN, and the immediate past ambassador to the United Kingdom, the immediate past High Commissioner, Honorable Justice Oguntade. They gave minority judgments, and the judgments were popular, yes, but that doesn't mean it's the judgment of the court. No matter how popular a judgment, minority judgment is, it's not the judgment of the court. It's an opinion.
So that's settled.
And it ends there.
That is the basis of the confidence of the party.
Yes.
And you've given the party this legal advice.
Of course, it's there.
Let me take you, Chief Akintola, quickly to this. What Mr. Keyama said, and this is his fear. He's a senior advocate of Nigeria.
He is my junior. We appeared with me against in Atiku's matter. He appeared with me several times. And I sent him a message. Was this from you? He replied me just yesterday to say he was expressing a fear. And I said that fear was unfounded. You see, we are trained as lawyers not to be flippant. We are trained to speak strictly. It's not about sentiment.
Was that statement flippant?
I'm not saying that. But what I'm saying is that when you express an opinion, when you speak as a lawyer and as a senior advocate of Nigeria, you should be mindful of what comes out of you. Because, one, it carries weight. People will read meanings into it, apart from your own position. And don't forget, becoming a senior advocate of Nigeria is not a tea party. You are made to swear to an oath, just like the president and the governor, to uphold the position of the Constitution. Everything that every governor swears to, and Mr. President, is what a senior advocate of Nigeria swears to. So, to that extent, you are expected to uphold the Constitution, the rule of law. The court has given a judgment on this. Criticism of such should not come out from the mouth of a lawyer. That should be left to the sociologists, the academia, and of course, the members of the public. It should not be from a senior lawyer.
Okay. So, because this is coming from a fellow learned colleague of yours, yes, and you said he's your junior. Well, let's look at the meat of the fear that he has. And whether or not he should not express it doesn't mean that that fear does not exist. And it says, and I
quote, he has expressed his discussional right, but I'm just saying, by virtue of his position, apart from being a very senior member of the bar, he's also a very senior member of the government. He's also and of the party. He actually sat and midwife the bat of this caretaker committee.
But it was a leaked memo. It wasn't a public document.
Well, I saw it. It was
a memo that was...
over 50, if I remember correctly, 53 people forwarded it to me. From different... 53.
But that was after it was leaked.
After it was leaked. And immediately, I sent him a WhatsApp message. My brother, is this from you?
Because when we called...
And he replied me yesterday.
When we called the minister to confirm whether or not he asked, where did you get it? That was the first question.
It was leaked. I got it from
reluctant
53 different...
Because he said, according to him, it's a confidential document. That's
yes,
what he said.
So it was headed confidential.
Okay, so now, if you look at what he said, quote, therefore, any other person affected by the actions of the Buni-led committee will henceforth not fail to join him in any subsequent case in court. This includes any subsequent election matter in any part of this country and all the APC congresses they are about to hold. He went further to say the Supreme Court has just weaponized all those that would be aggrieved by the APC congresses to proceed to court to challenge the competence of the Buni-led caretaker and caretaker committee to organize the congresses and national convention. These are his fears. That
let me address.
We cannot gamble with this delicate issue. The time to act is now. And he gave advice. He gave 2 options for the party.
Yeah, we appreciate that. But let me say this. 1, he was not seized of the facts of the case. 2, he was not a party to the case. 3, he was not in court. 4, he knew nothing about the outcome, the ratio of the 3 layers of court. The ratios that were given by the 3 layers of court, because he was not there. He ought to have at least found out, to have taken the step to examine what was the position. He could have called any of us. We are all his colleagues, his brothers. We have called any of us. What's happening there? And then we'll give him. I haven't sent it to him to his mail. You see, I'm telling you, the foundation of the Supreme Court case was the tribunal case, where the tribunal found that holding party position was not in any way in conflict. Expressly stated in the judgment, was not in conflict with the provision of Section 183 of the Constitution. And that was confirmed by the Court of Appeal. That was confirmed by. So there was no way the justice of the Supreme Court, I'm talking of the majority judgment now. There was no way the 3 justices made any reference to the idea of holding party position. All they said was that because we raised 4 layers of objections to the case. As a matter of fact, we even crossed the examination because we felt that one of the objections was not pronounced upon. So we even filed cross appeal, and we felt that it was only the Supreme Court that has the power to decide a matter without going to the merit. So to that extent, if my landed brother, Mr. Keyama, whom I have greatest respect, if he had taken the step to ask us what was the situation, he would have been briefed.
Well,
so he was not seized of the fact.
Senior Advocate,
yes.
Should Governor Memo have been joined in this matter, perhaps this case wouldn't have, the case would have been different, or the outcome of the...
It should have been made in the first place. The electoral act is very clear. See, I'm surprised. I'm sorry. It's not in my character to come to television because I'm not a television lawyer. I know you know. You've made several attempts to bring me here. I've refused to come. You see, it's not in my character to start referring to provision of the Constitution, case laws, and what have you. But let's face it. The electoral act is very clear. There are certain categories of people that you cannot even join. Was Malabuni a participant in the Ondo State election? Was he an INEC man? Was he the contestant? Was he the respondent? I could have joined him in the first place. You see, if anybody makes such attempt, we are waiting for them.
What about the fact that as a leader of the party, he led the process that produced Governor Akeredolu as a candidate of the party?
The party has been sued. The party is an institution. The party is an institution.
But he is a signatory.
Yes.
He was a signatory to the process.
The mere fact that he was a signatory doesn't mean the party is an institution that can be sued, that can sue and be sued.
But this is not the first time that we are seeing officials of party being joined in matters of this nature.
Yes, not an outsider, as it were, in this case.
Is he an outsider? The leader of the party, the chairman of the
state
party?
Election, yes, he is.
Was he not the one who submitted the name of Governor Akeredolu to INEC?
The party submitted it. He was acting. He's an agent on the part. He's an agent of a disclosed principle. You can't hold him. The party, whatever he does, is doing so in the name of the party.
And it cannot be invalidated based on Section 183.
Certainly not. Certainly not.
But the question is that...
And for those of them who are gearing up, we are waiting for them. You see, you should be able to anticipate your opponent. You see, when the petition started, Alane brothers Jegede was actually challenging the election. But later, somewhere along the line, he beat a retreat. And now, started crying louder than the bereaved. He is not a member of our party. So we challenge his locus on that ground. It was supposed to be an internal affairs of our party that no courthouse jurisdiction will challenge on that ground. Then we went further to say that, look, this petition was even filed out of time. The election result, the election was conducted on the 10th of October. Result declared that you filed the petition on the 30th of October. It was outside because as at that time, unfortunately, they didn't take cognizance of the fourth alteration to the Constitution. The time within which to file petition as, and like I did say, it's not in my character to go to television station and start referring to laws, and it's even unprofessional. So okay. I don't do it.
To wrap up this conversation, and because when I was speaking with some of the leaders of the party on this issue, and I was bringing them to the notice, I was bringing some of these issues to their notice and their reactions, getting their reactions, their very strong opinion is that there's need to have a strong legal opinion from the party's point of view, and they believe that you are the right man to do that. But give us a final word on this matter. You are not afraid of any future legal contestation?
No, whatsoever.
You are not worried that the party structure might collapse because if Governor Buni goes and conducts these congresses from ward to local government to state and the national convention, that might be challenged and might be
certainly not, because the Supreme Court, which is the apex court of the land, had made a pronouncement, and the pronouncement was a confirmation of the decision of the Court of Appeal, which in turn confirmed the decision of the tribunal. So anybody who believes in the rule of law should not make mountain out of a molehill over this issue. This is not the first time we are having minority judgment. A minority judgment is what it is, minority. Minority will have is say, the majority will have their way. That is the principle of democracy. No matter what you think, no matter me, it's not about your opinion or my opinion. It's the position of the law.
And the Supreme Court judgment is law.
It's law. And we have all sworn to obey the provisions of the Constitution. And this Constitution you are holding enjoined everybody, especially every institution, to enforce the judgment of the Court of Records. The Tribunal, the Court of Appeal, and the Supreme Court are courts of records.
All right. Chief Adeniyi Akintola, Senior Advocate of Nigeria and Chieftain of the All Progressives Congress, an aspirant in the Oyo State governorship race in 2019. Thank you so much indeed. It's a pleasure seeing you at last in our studio. Thank you so much for coming.
Thank you for having me. Thank you for having me.